The views, information, and opinions expressed in Forum 360 are those of the guests and hosts and not those of PBS Western Reserve, its partners, or underwriters.
From swallowing nickels to the United States Supreme Court, from survival to success, from foster care to Supreme Court fanfare. Arguably, the most significant employment law case that the United States Supreme Court decided this term, and decided it 9-0, comes from Northeast Ohio, and the case is Ames versus Ohio Department of Youth Services. The lawyer who won that case is Northeast Ohio's own distinguished attorney and author, Attorney Edward L. Gilbert. We are honored today to have Mr. Gilbert on Forum 360, the show with a global outlook but local perspective, and we're going to hear his personal story as well as the lessons to be learned from his recent seminal case. On behalf of Forum 360, welcome.
Thank you, Sally.
And
great to be here.
It's great to have you here, and for our audience, and I'm Sally Henning. So tell us about not just this case, but before we get to this case, we'd like to talk to you about your upbringing, which is unique. You wrote a book a few years ago called Swallowing Nickels.
That's true.
Could you tell us about your upbringing in foster care and
yes,
your struggles?
Sally, I met my mother when I was 2 weeks shy of my 18th birthday. I met my dad when I was 13 years old. And from 9 months old until 13, I was raised in foster care in Indianapolis, Indiana. And it was a tough situation, and my dad, when he found out that I was probably going to be adopted, he then came out of nowhere and was able to secure me and my brother from foster care, and then we moved from Indianapolis, Indiana to Zanesville, Ohio, and I went to high school in Zanesville, Ohio, and so forth. And unfortunately, my dad was he was abusive, and unfortunately, we had to go back into foster care even after coming and living with our dad. So I spent a good portion of my younger years, lion's share of my younger years, with the exception of 4 years, in foster care. And in those days, they called it welfare. We were in welfare homes. We were welfare kids. And so the title of my book, Swallowing Nickels, takes me back, and this is, writing that book was sort of a therapy for me, you know, therapy of, because I never talked about that too much, and very few people who think they know me well do not know that I went through that, because I just didn't talk about it. But
well, they see an attorney,
yes, right,
who is a member of every group, who's honored, who's on TV, who gets interviewed all the time, who goes to the United States Supreme Court and wins 9-0.
Yes.
If I were to recite all of your achievements and all of your education and all your courses that you went to and that you taught, that would be the entire show.
Well, I appreciate it, yes. But it has not been easy, and my wife and my son, they really got on me about writing this book to see if I could maybe inspire some of the younger kids on that. And just to go to the title of my book,
Swallowing Nickels.
Swallowing Nickels. Yeah, I was about 7 or 8 at that time, and I was in this is my second welfare home in Indianapolis, and we did not have much to eat, and in fact, it was very, very, very difficult. And we had this one guy who would come down the alley behind our home there, and we were what we call welfare kids, and we always had our head shaved bald, and that was one thing that you could tell who the welfare kids were, because they were always bald head kids. And this a teenager would come by and he'd just laugh and laugh, and he would always want to slap our heads, and he would come to me and he says, "I'll give you a cookie if you let me slap your head." And I was hungry. I took a cookie and he would slap my head, but every now and then he would run out of cookies, and he would have, he says, okay, I'll give you a nickel if you let me slap your head twice. And I did. And as crazy as that sounds, it's so true. And I knew that
It doesn't
that
sound
was,
like crazy. It sounds like survival. Excuse me.
well, it was well, even in those days, it was embarrassing too. But, and I would hear all the old folks talking about, boy, you know, if I had money, I could go anywhere and do anything. And I remember them saying, money, if you just had money, boy, if I just had some money, I could get out of the predicament I'm in, and so forth. And I remember looking at TV, and we would only have this little small black and white TV, and all of us, it was about 10 or 12 people, the kids that stayed in there. They were called welfare homes, so they'd have a number of kids in there. And we'd look at that TV, and I remember watching Mickey Mouse, and if you wish upon a star, it makes no difference who you are. If you wish upon a star, your dreams can come true. And that's, you know, that's just a saying, and nobody really took it seriously, but I did. And I was just, man, I wish I could get out of this. And then them talked about money, and, you know, this guy would give me a nickel, and I'd go back, and I couldn't go anywhere. We weren't allowed to go to the store. I couldn't spend or anything, so I swallowed the nickel. In hopes that someday I would get out of my predicament. And it sounds crazy, it sounds stupid, but it was just dreaming. I just wanted to dream to get out of that situation. And lo and behold, nobody would come see us, but this one aunt would come by, Aunt Pearl. And every now and then Aunt Pearl would come by and see us. And I remember one day she came by, and we were sitting on the back porch eating off, we had that 10 plates we were eating out of, and bean cans we were drinking out of. And the bean can would cut your mouth if you weren't cut your lip. And I had my lip cut real bad that day. Aunt Pearl came, and she wasn't supposed to be there because they was always supposed to call before they came by. But I remember Aunt Pearl, we did not expect her, because when we knew that she would come, they would clean us up a little bit, you know. But that day, boy, my lip was bleeding, and I was drinking out of 10 cans, and Aunt Pearl just looked at me and started crying. And I remember within a few days, we were out of there and moved to another welfare home on the other side of Indianapolis, and on the east side. And that particular home was really very, very giving, very, very nice home, and they were very good to us, and that's when my life kind of turned around and so forth. And finally, my dad, he came and got us, and the rest is what you might call history, you know.
So that was the turning point.
That was a turning point. That was a turning point. And even though Dad was very difficult, he's always pulled, you know, guns on us and so forth, and threatened to kill us and so forth, and that we cost him too much money and that type of thing. And sure enough, my brother, he only lasted 2 years, and me, I lasted 4 years with him, and then we went back into the welfare system.
What kept you on the path? We call it the Derrick. What kept you on the path?
Fear. I mean, that was so hard until I just said, man, I had a fear of failing. That I was, the only thing I could look for in those days, you know, Martin Luther King, you'd see him on TV, and he'd always talk about education, always talk about doing better for yourself, helping somebody. And that just went through me. And I remember saying, look, if I get an education, maybe things will get better. And they did, considerably. And I just can't forget that. And I wonder about the kids today, and boy, if they just had a Martin Luther King to really talk to them about success, about doing the best you can, be the best you can no matter what. I remember his one speech, he said, even if you're a janitor, be the best janitor you can be. And that just stuck with me. And just so the fear of going back to where I was, it motivated me to go on to get a college degree from the College of Worcester, and then going on to the University of Akron, getting my law degree, and ultimately becoming a lawyer. I mean, that just, the fear of failure is what really motivated me.
So how many law schools in the United States, kudos to the University of Akron also, My
Well, when I
my-
came out, you mean how many I?
No. How many law schools have graduates who got a 9-0 decision at the
Oh.
United States Supreme Court? Like,
Well, it's less than 2%, I'm told. So we're real proud of that. And let me tell you a little bit about that case. Miss Ames is just a nice, dear lady. She's a heterosexual.
and this is the
And-
case that you took to the Supreme Court.
Yes, and at that time she was one of maybe 50 cases that I was working on, you know, and
Your
Miss-
normal caseload.
Yeah, my normal caseload in courts, you know, and generally I go to federal court. I'm doing more state work now, but this is one where she came to me and she explained to me two different situations which kind of took to me. And the first one is that, you know, her being a white heterosexual, she just indicated that she was denied a promotion and it was given to a gay person, and not because the gay person was gay, but the point is it was given to a person who didn't even apply for the job, did not interview for the job. And I thought that was wrong. That was just dead wrong.
What was the state of Ohio's explanation for not even interviewing or getting an application from the successful applicant?
Well, they said that the interview pool that they had, there were 3 people. All of them were heterosexuals, one including Mrs. Ames. And they said they did not have the vision for the job. And, you know, very subjective. And okay. And the person that they actually promoted to the job did not interview for the job, indicated she did not want the job, and that they basically forced her to take it, and she went on and took the job. And I'm not telling you something that is guesswork. I'm telling you something that,
In the record.
that is in the record, that is sworn to, deposition testimony, and so forth. And I thought that was wrong. And then she explained to me, while she was waiting for the results of the interviews, she was then demoted to a position that she had been with the agency for like 15, almost 20 years at the time. Very stellar record, great evaluations, and she was demoted in favor of another gay man. And he, in fact, did not interview for the job. They just gave him the job, and he bragged before then that he was going to get her job because he was gay, and that he had gay friends that'll make the decision, and he was going to get her job, and he was trying to force her to retire. And she says, I don't want to retire. But she explained both of those incidents to me, and I said, you know, that's not right. But the hurdle we had at that point is not the basic case. The basic case, I felt we could win, but the issue was the higher degree of basic evidence that you would have to present in a case like that, called background circumstances.
One moment. You're tuned into Forum 360. Our very special guest today is Attorney Edward Gilbert, who recently prevailed on behalf of his client in front of the United States Supreme Court in a 9-0 decision. Attorney Gilbert, you're just talking about what this case was about.
Right. And the thing is that in the basic format of what we call McDonnell-Douglas discrimination case, all you really have to show before you get to the jury is that you applied for the job, you're qualified for the job was not given to you, and that the job remained open. We had that, but there's another hurdle called background circumstances, which it's a judge-made rule, and this judge-made rule was instituted in the early 1980s in the District of D.C., and that was for cases where there are majority group people that complain about discrimination. You have to prove, according to that circuit, background circumstances.
So there's different standards if you're a majority person
Right.
filing a discrimination charge than if you're a minority person.
That's correct.
Even though sometimes women are majorities and sometimes they're minorities.
Well, that's part of the issue, because, you know, you and I went to law school together, and, you know, now, in those days, you didn't have very many women in law school, but now the majority are women, you know.
Well, I have stories.
Yeah. At any rate, in this case, what we're saying is that you would have to be, being that quote unquote majority group, you have to prove that you had background circumstances where the employer is an unusual employer that discriminates against the majority.
It's quite a stereotype, isn't it?
Yes, and that's hard to prove, and also it's sort of
discriminatory.
Yeah, and if you look at Title VII, the law, you know, any discrimination, white, black, is the same. You know, gender, race, religion, national origin, so forth, and you know, there's no difference. And in fact, in the case of Thurgood Marshall, handled way back when he first took the bench, right after Title VII was passed in 1964. This case is in the early 70s. Called Santa Fe, McDonald versus Santa Fe. That was a case where then there was a 9-0 decision from the U.S. Supreme Court that Thurgood Marshall marshaled through, which indicated that white individuals are covered by, or a majority group are covered by Title VII, which is the same law we're dealing with. And so this is not a sort of a new thing, but after so long, the circuit in D.C. started this background circumstances as being an additional burden or hurdle you have to jump, and this started moving across the country. And our circuit is the Sixth Circuit, which covers Michigan, Ohio, Kentucky, and Tennessee. They bought into that.
And it's a different definition. It's called reverse discrimination.
Right.
You know,
a lot
there's
of people
nothing
look at
reverse
it reverse.
about it.
Yeah, and all we're saying is, look, no matter who you are, majority or minority, you should be treated the same. And that's what this case was all about. And so when we took it through the trial court, the judge said, no, I got to follow Sixth Circuit precedent, and that's what we're going to do. And I asked, well, what is background circumstance? What do we have to do to prove that? Well, nobody knows. I mean, it bounces from court to court. It depends on who the judge is. So we take it up to Sixth Circuit. Sixth Circuit said, no, we're going to go with background circumstances. And then after that came out, there was one judge there on the Sixth Circuit that said he had to rule that way, but he thought it was wrong. And lo and behold, I got calls from at least 7 law school clinics.
Really?
That wanted to assist me in taking this case forward.
You're right at my next question, which
Right.
was, what were the logistics and how complicated was it to go to the
Yes.
Supreme Court?
Well, you know, I had a lot of help. I had a lot of help because I had a good 7 number of law schools who had what they call Supreme Court clinics that wanted to get involved in this case. I interviewed all of them, sat down and went through everything with them. I selected Chow Wang out of Virginia Law School. And he and I immediately clicked on what we wanted to do, how he wanted to do it. He was very supportive. His school was very supportive of it. And I decided, well, he's the guy I want to do this with. And so they had done a good deal of the background work in terms of statistical work, you know, because I practice in Ohio. And, you know, when you go to the Supreme Court, they're going to want to know, well, what's going on in California? What's going on in Maine? What's going on in Florida and so forth?
You don't keep up with that?
I don't keep up. I don't have that in my hip pocket, but they did. And so we put it all together, did the briefing,
The
submitted.
logistics are a nightmare.
Oh, you
the
know.
brief has to be printed.
Oh,
There
yeah,
has
you
to be
have
how
to.
many copies?
Yep, you go through that. You spend a good $2,000 to $5,000 just on printing and briefing. And so we went through that. They prepared the work, submitted it to me. We made some adjustments, some different type of things, and then we went for a writ of certiorari with the court, submitted it, and you know, it took a while for them to look at it and
The writ of
review
certiorari
it.
is you're taken into the court. You don't just file and walk in.
Right.
You have to ask for their
You
permission.
gotta make that request, and you have to say, look, that it's a matter of public interest, and we told the court that we had 19 states that required background circumstances, and the other states did not. And so there was a split of authority within the U.S. So that's one of the criteria, and of course it's public interest. And so we were able to put that together with the full assistance of Chow Wang there at the University of Virginia, and lo and behold, we hit the bell. They said, we'll take the case and we'll hear the case. And so at that point,
the Supreme Court accepted certiorari.
That's correct. And then you have to do a full layout brief, you know. So that's what we did. There's a reply. And lo and behold, we got 13 amicus briefs.
People that were supporting your position.
Agencies, primarily agencies, general of the Attorney General's office
Of the
United States wanted to come in, and
how often does that happen in your
that
practice?
rarely happens. Rarely happens. And the one agency that disappointed me, that did not support us in the briefing stage, was the NAACP Legal Defense Fund. I thought that was really interesting. And they indicate in their brief that they agree that Sixth Circuit was wrong, but they wanted the court to develop some type of mechanism for race cases, that type of thing. So I wouldn't agree with that.
And you've been involved as counsel for NAACP in many cases.
I'm still counsel for a number of the local Northeastern Ohio NAACPs, but we couldn't get.
Marshall was their attorney.
And we could not get them to change their mind on this. But at any rate, they did prepare. They were the one, I think there were like three amicus briefs that were against us, and we had like 13 that were for us. And it was just great. And just going to that court and walking through that court, I will tell you this, that I was disappointed to see this huge statue in the court of Marshall, Justice Marshall, who was a slave owner. I walked by him and I says, wait a minute, how's George Marshall
get here? You're welcome. Hello.
You know, he get off the bench and go out and sell slaves. Oh, gee. But at any rate, I was like, I couldn't believe that. But anyway, going through there and going through that and sitting there as a second chair, because, one of the things I said to Chow, I says, Chow, you can do the argument. And I said, well, I'll do the rebuttal. If they get into the factual situation and have questions about the facts, then I would do the rebuttal. However, if it's a continuation of his opening, he could do that. Well, as you probably listened to the argument.
I did listen to it on YouTube.
Yeah,
I did.
So
it's wonderful.
that's what happened. I mean, he did a great job on his opening, and then the reverse, the state of Ohio, they did not even use up all their time. I thought that was interesting.
They agreed with the basic principle.
Once they agreed with it and they did not raise the factual issues or disputes in the case, I told Chow, I said, Chow, you go ahead and do the brief rebuttal. So, and that's what happened. That's the way it laid out. Tell
me about your team at the Supreme Court.
Oh, well, it was just me and Chow. And then he had his students. And the students were just amazing, and he had a whole group of them, and they would do the background, particularly the statistical work, which was very interesting because, a lot of questions that raised about DI and all these other questions.
Your son, unlike you, whose parents were out, your son was there watching you and your case.
Yeah.
Your son was there with the team.
Yeah, believe it or not, he's a graduate from Cleveland Marshall Law School.
Wow.
In
Marshall,
Cleveland.
How good.
Yeah, so that
to see a statue.
So that's your namesake up there. So that statue. But at any rate, he was there, and he wasn't supposed to be there. He didn't decide to come until a week before the argument. He never thought we'd get to the Supreme Court, And I kept telling him, we're in. Oh, I don't know. So, but he decided to come, and then when he got there, they wouldn't let him in. And then he told the guard, I'm Ed Gilbert's son, and he says, come on in, I'll push a seat for you. And the place was loaded. I mean, it was just.
So from swallowing nickels to seeing your son watching you in the Supreme Court.
Yeah.
It's been a life.
It's been quite a run.
And you used to say that if you just had the money, you could do all these things. So now you have the money, you don't have time for anything, do you?
I always have time. Always have time for youngsters, always have time.
Speaking of youngsters, what advice do you have for children who might want to be interested in being champions?
You know, that
for justice.
follow your heart, number one. Number two, help people. You know, like as poor as I was, and I'll tell people as poor as I am now, and I'm nowhere near where I was, granted, but the point is I never forget where I came from, you know, and even if you came from good background, even if you came from parents or relatives that have money, never forget that there are people out there that just need some help, you know. And I got to tell you, you know, I got a lot of good help along the way.
And you do a lot of help for a lot of
Well,
people.
and I never will forget it. And the only thing I could leave young people with this thought is, you know, think about people that don't have. Think about people that are hurting, you know, and always treat people with respect and dignity, you know. And that's one thing I insist on in my office, and I insist on dealing with people that come into my office. When you call me, you'll always get through to talk to me.
You've been tuned in today to Forum 360. Our special guest, Attorney Edward L. Gilbert, author, counsel, just recently prevailed at the United States Supreme Court. On behalf of Forum 360, I'm Sally Henning.
Forum 360 is brought to you by John S. and James L. Knight Foundation, the Akron Community Foundation, Hudson Community Television, the Rubber City Radio Group, Shaw Jewish Community Center of Akron, Blue Green, Electric Impulse Communications, and Forum 360 supporters.